Welcome to the Ad Watchers, a podcast brought to you by the National Advertising Division of BBB National Programs.
We're a team of attorneys with 50 years of experience investigating and resolving disputes over the truthfulness and accuracy of national advertising campaigns.
I'm Hal Hodes.
And I'm La Toya Sutton. To make sure advertisers can back up what they're telling consumers, we don't just take ads at face value. We put them to the test. Why?
Because advertising law is simple. It's the execution that's hard. Thank you for joining us. This is our inaugural episode of the Ad Watchers. And La Toya, before we really dive into the issues we're going to talk about today, I kind of wanted to talk about what our goals are here with this podcast. La Toya, what are your goals here?
So what we really are trying to do for the listeners is to provide a behind the scenes look at the NAD process, give our listeners some insight into kind of how we think, how we view advertisements and different claims, how we think about what they mean to consumers, the different issues that come up in our daily lives as NAD attorneys, what kind of evidence we think, certain claims should be supported by, all of the things that, go into the thought process that results in our ultimate decisions that we issue.
Yeah, I think we want to be non-specific. We're not here to talk about specific advertisers or advertisements that much, but we often say that we step into the shoes of the consumer to determine what messages are conveyed by an advertisement or an advertising claim. And I think I would like that at the end of this series that our listeners would have a better understanding of how we do that, how we look at advertising from a consumer standpoint.
Exactly. We want to, help the listener when they're developing their advertising, know what to do, what to look for, in order to ensure that their advertising is truthful and substantiated.
Yeah. And so, as for who our listeners might be, if you've been an NAD participant either once or often, if you might be an NAD participant in the future, if you work in advertising claims or marketing, or have read our decisions in the past and were curious about them, or maybe you're just someone who's interested in the nitty-gritty of truthfulness in advertising, I think this podcast is hopefully useful for all of those people.
So what we're saying is basically there's a little bit for everybody. So I guess with that, we should just, jump right in and get started. What do you think?
Let's do it.
All right. So today we're going to be talking about, an issue that comes up over and over again. One of the very basic questions that all NAD attorneys get asked over and over again is, who makes the rules? Is it you? Are you making this up as you go along? Who makes the rules that we're looking at when we're deciding cases? And the truth is, there are a lot of people that, play a part in making the rules that we look at, and a lot of federal agencies that we consider. It's basically the federal alphabet soup. There's the FTC, there's the EPA, there's the FDA, sometimes even the CPSC gets in there. So the truth is, there are a lot of different places that we look for advertising standards.
Yeah, and the one alphabet soup that doesn't make the rules is NAD, right? We don't just make up these rules. We look to the law and regulatory guidance that's already out there. And then we seek to, what we always say is we seek to harmonize our decisions and our recommendations with those standards set by, the various agencies that are relevant to whatever the claim might be. And, that gets complicated because a lot of the products that are the subject of the ad claims we review are really heavily regulated. And there's a lot out there about what they can say, what they can't say, what they can do, what they can't do. And, you know, that makes our analysis of advertising claims difficult sometimes. But first and foremost, we want to make sure that consumers are being provided with truthful and accurate information, right? So that's always our primary goal. So how do we do that in this situation? We don't want a situation where we believe that in order for consumers to get truthful and accurate information from an advertiser, that they need to do something different or contradictory to a regulation or a law, right? That's not what we're here to do. We
Exactly.
want to have consistent rules and standards, right?
Exactly. That's consistency is our ultimate goal. We don't want to have a situation where it's difficult for an advertiser to both follow a federal regulation and what NAD has said in its decision. We don't want there to be conflict. So let's talk a little bit about how we do that.
All right. So when there's an applicable federal regulation or there's an agency that directly relates to the product or claim before NAD, like an FDA monograph or an EPA designation, NAD will, as I mentioned before, attempt to harmonize its efforts with those of that appropriate regulatory agency.
Right. And harmonizing, that doesn't mean that we are in the business of determining if you're complying with federal regulation. Sometimes we have parties that come in and say, this claim is a problem because it doesn't meet FDA's, definition of a health claim, or it is improperly formatted structure function claim. Those are terms of art and standards that are defined by the FDA. We're not here to say, yes or no, we are enforcing FDA's regulations. That's not what we do.
Right. There's a case that I often go back to about one of my favorite all-time products, mozzarella cheese. I know La Toya is also a mozzarella fan, and I'm not going to endorse my favorite mozzarella cheeses on this podcast, but La Toya, you could feel free to reach out later, or any of the listeners can as well, because a lot of them know us already. But in this case, there was an advertiser who was calling their cheese part skim mozzarella cheese, and a competing cheesemaker said, no, we've analyzed it. This doesn't meet FDA regulations for part skim mozzarella. And we took the case on. We had jurisdiction, but we made clear that we weren't determining whether or not the advertiser was complying with FDA's regulation about what is mozzarella cheese, as opposed to some sort of processed cheese, right? We use that sort of regulation as guidance for what consumers understand mozzarella cheese to be, and whether or not the advertiser was being truthful to consumers and meeting their understanding of what the product identification was.
Right. Because, you mentioned that, we considered our jurisdiction in that case. Our procedures do sort of preclude jurisdiction over language that is mandated or expressly approved by federal law or regulation. And so that is another reason why we, have an interest in harmonizing. We aren't there to, set a standard or decide what should or should not be in an advertisement in a way that conflicts with federally mandated language. Again, we don't set the standard, we're just applying it. Another place that this comes up often is when we are looking at a product that is subject to an FDA monograph. In that case, we really consider the monograph to be the standard that we are applying. That if the FDA has determined that a product that is formulated by this monograph can make certain types of claims, then we are going to go with the presumption that the FDA has determined that, whatever's in this monograph, that's a reasonable basis for making that claim. We believe that the FDA, they've done the research, they've determined that the approved claim is truthful, and so we don't need to really revisit that issue.
Yeah, and that gets tricky because some of the monographs are older and maybe the science has changed a bit, or maybe the challenger in a particular case disagrees with the underlying evidence that led to that monograph, right? And so we get plenty of challengers saying, no, the product doesn't do what it says it's going to do. And they try and show that to us, but it's not our job to sit there and say that the regulation is wrong. I mean, we have to put some trust that the laws and regulations in place are based on good evidence. And also, to the point of harmonizing, given that choice of going up against determination that in a monograph that a product can say that it does X, Y, or Z, we're going to try and harmonize our decisions with that, as opposed to revisiting the whole background of evidence, much of which we don't have access to determine if the monograph is correct or not.
Exactly. There are a lot of scientists that, work at the FDA, that work at all these other different federal agencies, who spend their entire career looking at a specific issue or specific type of product or a specific type of ingredient. And, they've done their homework. And so again, if they've approved a claim, we're not going to be, the ones to question it.
Yeah, I mean, to the point of applying standards, not setting it, the FDA has applied a standard, right? And we are not going to set one in its place, given an existing, well-established standard like that, especially if it's coming from a federal agency. So, this maybe goes a little deeper into harmonizing where maybe it's not so clear, right? Like a monograph. And we kind of alluded to this in talking about monographs, but what I think harmonizing often means is looking to the regulations for guidance about what an advertisement means to consumers and what kind of evidence is expected when a certain claim is made. We know that regulations are in place and that consumers see advertising that is regulated, right? Or that is based on regulated products. And so, they're kind of used to seeing advertising based on these rules and regulations in this law. So it kind of guides consumer understanding.
Yeah, definitely. Regulations shape how consumers understand terms and ads and labeling, and it also, to a certain extent, is reactive to the real world understanding of terms and claims. It's a bit of a chicken and the egg situation sometimes. Which comes first? Do regulations shape how consumers understand things, or does consumer understanding kind of shape regulations? I think in a perfect world it kind of goes both ways. there
Yeah,
the,
yeah.
there are times where you have a regulation that's based on consumer understanding from the 70s, and then it'll get updated once there's more evidence of how consumers are understanding that claim in 2021 perhaps. So I think it goes back and forth, right, Hal?
Yeah, I mean, whether it's a chicken or an egg, it's all the same species, right? And so it doesn't really, as what we care about, I think, in looking to harmonize our guidance with that of federal regulation, is that it kind of doesn't matter which one comes first. If the guidance from federal regulatory agencies lines up with consumer understanding, whichever one came first, we want to take that to heart and use that in making our own determinations and stepping into the shoes of consumers, because consumers, views often line up with those laid out in regulatory guidance. But sometimes I think, if some of the listeners here who look at our decisions regularly and have read a lot of them might say, you don't always do that, right? Sometimes you don't follow regulation or regulatory guidance, and what are you guys doing here? Help us here, because how do we know when you are or not going to follow the letter of the law in regulation? Like I said, we don't enforce. You said actually, we don't enforce the regulations, right? We apply we apply them, and we use them as guidance as to what consumer understanding of a claim is and whether or not it's substantiated. So how do we bridge that gap, and how do we how do we sometimes not use that regulation to bridge that gap?
Yeah, absolutely. I know there are probably some listeners about to pick up the phone and call NAD offices and say, wait, you didn't do that in my case. So let us explain. Yes, it does seem contradictory. We'll get to why it's not, but we fully admit sometimes we don't follow the regulatory guidance, and it comes up in a few different ways in our cases. One of them is 510K products and medical devices that have an associated 510K. We sometimes get the argument that, our 510K allows us to say this, and we might decide, this is still a misleading claim. Another place it often comes up in is FSIS, administrative reviews for meat and poultry items, where again, an advertiser might say, well, our label has been reviewed by this federal agency, and they've made a determination about what we can and cannot say, and NAD shouldn't, go against that. And I think what's important to distinguish with these cases and these issues as opposed to federal regulations is that these are administrative reviews. These are not necessarily representative of the entire agency's thinking. They're kind of very specific to one advertiser, and in many instances, one sort of narrow review of the claims or issues that are presented. I think that our decision in Sentry FibroGuard is a really good illustration here, because that case involved some approved language that was on the package for a pet pesticide product. But, when we looked at the case and whether or not we had jurisdiction over, the claim that was at issue, one of the really key issues was kind of, defining what it means to have language that is approved or mandated, and that's different from an agency determination that applies to a specific advertiser. What we're talking about is regulations or language or things that apply to the industry as a whole, that all advertisers that are making these types of claims need to adhere to. On the flip side, where you have this administrative review that is really kind of unique to a particular claim, it doesn't really disturb the regulatory scheme if self-regulation makes a decision that's contrary to that determination. So really, the ultimate takeaway, and this is something that has been reflected in a number of NARB decisions, is that an administrative review that didn't necessarily consider all of the messages possibly conveyed to consumers doesn't need to be followed by NAD.
Yeah, I mean, we often look deeply at implied messages. And that's something that we think is important because advertising doesn't, it doesn't always, when it's making an unsupported claim, sometimes that is not so clear, but consumers are still taking away an unsupported message, right? And so, speaking of FSIS reviews, I know there was a case recently with a chicken product label where the imagery showed chickens sort of fancifully, you know, wandering in an open field, uh, associated with also a cage-free claim. Right now, cage-free doesn't mean wandering in an open field, but we did look at that label and that imagery to determine if it conveyed, not necessarily the cage-free language, right? Like that's harmonizing with the regulation, right? What does cage-free mean? There's kind of overriding rules on that. But when it comes to an implied message from the imagery on the label, even if that label was approved in an administrative review, we're going to look at whether or not it implies that cage free means something greater than the actual regulatory guidance.
Exactly, because we know that the agency likely looked at the words on the package and considered whether they were appropriate. But there's nothing indicating that they looked at the implied claims, looked at the consumer takeaway from this fanciful chicken imagery on the package or other places that it was used in the advertising, because it also appeared on the website. We took into consideration, I think, sort of the bigger picture and the bigger consumer takeaway that just, again, wasn't unlikely to have been considered by the agency review.
Yeah, I mean, and putting consumers first, we're going to do that and make sure it doesn't contradict, clearly the guidance in place. There's another way in which sometimes I think people that come to NAD, advocates and businesses, view our decisions as contrary on occasion to regulatory guidance, when it's really just narrowly reading the guidance. So another sort of pet flea and tick case that I was looking at recently involved the word pesticide, right? Could you say not a pesticide for a product? EPA says that a pesticide, defines a pesticide and has sort of rules over what's a pesticide. And a lot of these flea and tick products that are applied to your pet, on the outside qualify as pesticides. There was a product called Revolution that we had a case on a long time ago. It was orally intake. It was like a tablet or a pill that the dog took, and then it extruded the pesticide through its skin and its pores onto the surface of its skin to fight off fleas and ticks. They were saying not a pesticide. For consumers, and by the way, that is not an EPA regulated product, right? Because you take it orally. It's an FDA issue. So for consumers' standpoint, pesticide means that there's toxic or poisonous things on the surface of your pet, right? That whether it comes from the outside and meets EPA's regulation for a pesticide, or it's not an EPA regulated product, but it functionally is the same thing. We said you could not, that advertiser could not say not a pesticide. And that's something that NARB agreed with. And we view the EPA regulation narrowly applying to products that it regulates, and we did not allow the advertiser to use that regulation to make a claim that we felt was misleading to consumers.
Exactly. And I think that also kind of circles back to our discussion earlier about, the influence that regulations and the standards set in regulations can have on consumer understanding. Like regardless of whether that product met EPA's narrow definition and kind of was technically correct, really what it came down to is knowing what consumers know about pesticides. Is this going to be misleading? Is this going to be confusing? And I think that's really what guided our decision.
Yeah, I mean, the impetus of the EP regulation applied to this product, right? Like It's not like in determining that a pesticide is sort of something that's applied on the outside of the dog and that has these characteristics. That aligns with consumer understanding for what is a pesticide, even if it's a product that's not regulated by the EPA and wouldn't technically be a pesticide under that regulation, right? Functionally, based on consumer understanding, which lines up with the EPA regulation, this product was a pesticide, or at least was not a pesticide. And so we recommended that the advertiser discontinue that claim. So La Toya, is there a method to the madness here? Are we just constantly contradicting ourselves when it comes to harmonizing with the appropriate regulatory guidance? Or is there sort of a unified theory of harmonization here that we could help our listeners and our users sort of understand through this discussion?
I mean, I think it's completely clear, but let's break it down for the listeners. I think first of all, consumer understanding comes first. That's always, been a guiding principle for all NAD decisions. And I think that's always where we're going to start. Consumer understanding of the claim, of the advertising is, ground zero. Um, from there, NAD is going to look at whether or not the cited guidance is a rule or regulation that is standard setting. Is it something that is mandated, that is, telling us this is the way things need to be? Or is it the result of an administrative review, which again may not have taken into consideration all of the potential implied messages subtly conveyed, such as a 510K application or an FSIS review? If it is a regulation, if it is a standard that has been set, then we're going to look at, does it help us understand what messages consumers would reasonably take away? Is there a general consumer understanding of a claim or a term that we can glean from this regulation? And then, finally, we're going to look at our understanding of the consumer takeaway and whether or not it contradicts the regulation. We've looked at the evidence, we've looked at what consumers understand. Is our ultimate decision going to contradict the regulation, or is there something that we need to do to make sure, kind of going back to the beginning, it is not difficult to comply with the federal regulation and comply with NAD's ultimate decision and recommendations?
Couldn't have been clearer myself, La Toya. In fact, I almost certainly would not have been clearer myself. So thank you. But I think this lines up perfectly with sort of what we were saying at the top, which is consumers and consumer understanding, stepping into the shoes of consumers is always going to be our goal, and making sure that they're getting truthful and accurate information. And our second goal is having clear, useful guidance for advertisers, that they don't have to be in a situation where they don't know what rules to follow in substantiating their claims, in developing their claims, and that it's as clear as possible while also being as truthful as possible. So, what are some final tips and takeaways from you, La Toya, to kind of sum up what advertisers might want to take away from all of this?
Well, don't lie and don't break the law. Boom, done. You've
Easy, right?
we're all good. No. A little bit more seriously. I think a key takeaway that I hope our listeners have gotten out of our time together today is that following regulations by itself, may not insulate you from scrutiny about whether your claims are truthful and substantiated. Um, It helps, definitely, but we at NAD believe that truthfulness and accuracy deserve their own review. So we're going to really still scrutinize claims, even those that the advertiser defends as compliant with a federal regulation.
I think that's great, simple advice, which is, maybe hard in the execution, and that's why we still have lots of cases coming in the door. But I think that's very useful advice. So thank you, La Toya. Thank you to all of our listeners for joining us on this first episode of the Ad Watchers. We hope you continue following us and listening to our next episodes. We'll be back next month with another episode talking about the reasonable basis standard, which is pretty ubiquitous when it comes to NAD's review of advertising. In the meantime, you can go over to our website, bbvprograms.org, to learn more about our organization, what we do. And thank you again.
See you next time.